Welcome to the Centre for Public Integrity. The Centre is considered by many to be Australia's leading democracy research institute. In our podcasts, we aim to bring listeners with us as we explore with key thinkers and participants just how our democracy works. I'm Michael Barker, former Federal Court judge and a director at the Centre. This podcast is a special edition podcast in advance of the National Schools Constitutional Convention to be held in March this year in Canberra. The convention comes in the wake of the 50-year anniversary of the Whitlam dismissal, which was 11 November last year. The students will be reviewing the powers of the Senate, particularly with respect to the budget, and grappling with the history and operation of Section 53 of the Commonwealth Constitution, and asking whether it should be amended to prevent the Senate from blocking supply, as it did in 1975, or rejecting money bills. The ultimate question, I suppose, is this: is Section 53 fit for purpose in light of the Whitlam dismissal? My guest today to grapple with that question is Professor Gabrielle Appleby. Gabriel is wonderfully qualified to address Section 53. She's a Research Director at the Centre for Public Integrity, Professor of Public Law at the University of New South Wales, and Constitutional Consultant to the Clerk of the House of Representatives of the Commonwealth Parliament. Welcome to the podcast, Gabriel.
Thanks, Michael. Pleasure to be here.
It's a fascinating topic. I mean, Section 53 on the face of it's very dry. You mentioned the word Senate, immediately reminds us all that most legislatures in Australia and the Commonwealth, one in Canberra, are bicameral. They have what's sometimes referred to as lower and upper houses, as though the upper house is more important than the lower house. But there are very few exceptions to the bicameral nature, and it makes you wonder just how this is all meant to work. New Zealand only has a unicam parliament. The US Congress, of course, has a Senate and House of Representatives, and you might touch upon whether that is relevant to our discussion. And of course, the Australian colonies all followed Westminster pretty much in the first instance, with an upper house in Westminster, the House of Lords, and a lower house or an assembly like the House of Commons, similar to. When you look at Section 53, I find it highly instructive. It's headed Powers of the Houses in respect of legislation. And I'd encourage everyone to go and read the very last paragraph of Section 53, which says, except as provided in this section, the Senate shall have equal power with the House of Representatives in respect of all proposed laws. Now, students, with a capital S and a little s of constitutional law, will wonder what it means to have equal power. Can you actually have, in effect, two legislators making sure what Australia's laws are, they ought to be, and changing them, and fiddling with them? But more importantly, except as provided in this section. Can you tell our listeners, in essence, what the except as provided in this section means?
Yeah, sure. Look, as you say, Section 53, it's a detailed, technical, dry provision, but it is actually a real workhorse of the Constitution. It's one of those provisions that is constantly being used, but it's being used in the political branches of government, in the executive, in the parliament, and they're constantly interpreting it, having struggles over it, and particularly between the two houses, as you just mentioned. In simple terms, what it does, it relates to what we call money bills, which are supply and taxation bills. Bills that allow the government to spend money, supply the government with money, and bills that allow the government to raise money, taxation. And we can talk about how important money is to government in a minute. But this provision regulates supply and tax bills, and it says that these must start in the lower house, the House of Representatives. The Senate cannot commence these bills. It cannot amend these tax bills or bills for ordinary government spending. They're the annual budget bills, the annual supply bills. But as you say, that last sentence of Section 53 says that otherwise the Senate has equal powers with the House of Representatives, which means really by silence, the Senate can still reject these types of bills, or it can, what we call sort of fail to pass them, delay them, possibly for an indefinite period of time. And that's a really, really important power. It can potentially be used to hold the government, shall we say, to ransom. And we see that play out in the 1975 constitutional crisis. But that's what those last words mean. Sort of otherwise, the Senate can reject or delay these money bills.
It's really an interesting topic, and you make a good point with respect, as we lawyers always say to each other, and that making a decision is sometimes not making a decision. You've got something in front of you in the Senate, and you sit on it. You go and make yourself a flat white, or you go for a 9 holes of golf, or you walk around Lake Burley Griffin, and you don't do anything with it. And everyone's saying that the machinery of government is about to break down. We become familiar with the US Congress not passing in effect supply, and federal bureaucrats not being paid any money, and a constitutional dilemma and impasse happens. Just want to ask a question in a broad sense for anybody who's a student of politics or government. If the two houses of the Australian Parliament did have just equal power, full stop, what would it mean? What might it look like when it comes to appropriation bills, supply bills? What would they would each, on the face of it, be able to start their own taxation processes?
Well, that's right. They can start their own taxation processes, or they can start their own spending processes. And of course, this was actually one of the reasons why back in the British history, these restrictions came to pass, was you had members of Parliament introducing, non-government members of Parliament introducing projects that would spend money in their electorates, that would spend money that would be of benefit to their electorates. And there was all these little spending projects being introduced into the Parliament. It was chaos. It was budgetary chaos. And so what's called the financial initiative of the Crown, which is that government power, that sole government power to initiate these bills, means, yes, the government is accountable to Parliament, but there needs to be this single place of budgetary decisions. And that rests with the government to avoid these kind of fragmented, potentially self-interested money bills being introduced, of course, because, money is such a powerful tool of government, Michael. Bob Dylan once very famously said in one of his songs, money doesn't talk, it swears. Money is the power of government. Who gets it to have it, who gets to spend it, where it gets spent. Really, control over money is control over government. And if you go back into the UK, which is obviously where the Australian colonies and the framers looked, those big tussles between the Crown and Parliament, they were over money, over who controlled money, over who was introducing money bills and who could spend money, who give permission to spend money. What's sometimes called the power of the purse. Yeah.
Power of the purse. Well, I'm pleased to hear about Bob Dylan. It's very clear then why he won a Nobel Prize for poetry. Yes, it can be swearing, and of course, particularly in the Australian setting, but in the UK setting as well, so much is done in the name of the Crown. You've got Crown lands in Australia. When the colonies were first set up, they needed to be disposed of. Tremendous control over resources. And the idea that you can't originate a money bill, broadly defined, without the Crown introducing it and then coming to each of the houses of the parliaments is fascinating. I think we're also in the modern era aware of the sort of pork barreling allegations made in respect of the legislature, the Congress in the US. So someone from Idaho, if they have pigs or something, wants to have a pig-friendly law, and they trade across the House as to who's going to get what put into the appropriation bills. And I suppose you could have that sort of negotiating if you didn't have a Section 53. You'd have to get there somehow. But what about in Australia in the early colonial days? Was there serious suggestions that the upper houses should have a taxation power?
Yeah, look, I mean, the Australian colonies and then the Australian federal project is a really interesting study in tensions between constitutional principles, particularly when it comes to money bills. Actually, money bills and the sort of the compromise that's in Section 53 reflects one of the clearest examples of how the framers had to compromise. Because when we're talking about framers, of course, we are talking about a group of people who share a pretty narrow set of characteristics. We're talking about white men who are property owners or people of wealth. Most of them are colonial politicians or jurists. So their concerns, their aspirations for what Australia is going to be don't reflect all Australians. We just have to remember that. We're talking about a group of people, a relatively small group of people. But nonetheless, the Australian Federation project was actually seen to be a real, shall we say, democratic experiment, a real progress in relation to democracy. And one of the dimensions of that was to create not just a democratically elected lower house, but to create a democratically elected upper house, right? And so you have increased democracy from what was practiced in the UK. But we are still looking to the UK in terms of our Westminster system and responsible government, which means that our government is still drawn from the lower house, from the House of Representatives. They have to hold the confidence of the lower house in order to be commissioned to form government and become ministers and prime ministers, for example. So you've got a broader democratic base across both houses, different from the UK, where you don't have a democratically elected House of Lords, but still responsibility to the lower house. And then you add into that mix, right, federalism, because, of course, the colonies are coming together. And that adds a whole additional tension because the Senate is not only a democratic house, it's the state's house. And you want to jump in?
Well, you've just reminded me of something, and that is every time there's an election of any sort in Western Australia where I'm based, it's like federation is starting or being debated all over again because the West Australians don't want to give anything up to those on the eastern side of the country, and that includes South Australia. They're worried that all of those other states will just band together and make things bad for us here. In recent times, we've had all sorts of political debates about the GST, which Australia's done quite well in, but that's because of politics. But in the early days, I was brought up to believe that the local parliamentarians here, the Sir John Forrests of the world, the first responsible government premier of Western Australia in the 1890s, later Lord Forrest, was really worried about the federal process and what Section 53 might mean.
Yeah, look, because you have to remember that at the time of federation, the states were not equal, just like they are unequal today in terms of size, in terms of geographic size, population size, in terms of economy and wealth, right? There was massive inequalities. And there's also ideological differences between the states. And the particular divide back in the 1890s was between protectionism and free trade. That's probably not the divide that the states fall upon today. But, there are still ideological divides across the states in a sense of there are certain groupings of states and there are states that are worried, the smaller states in particular, states that are worried that they will be swamped and not have a proper voice in the national parliament, not be represented, not get enough money by the larger states. And when you see the makeup of the Senate in the Constitution and the guarantee of equal representation even for those smaller states, that was a key part of the federal compromise. But what it meant is you now have an upper house that is democratically elected and represents the states equally. So how do you balance that up against the idea coming from the old UK traditions that the power of the purse needs to be held by the democratically elected parliament? Where do you go? The lower house? The upper house? Who is going to be the holder of the purse strings?
Well, I'm assuming that in the course of that consideration, you look at how things were working out in the Australian context leading up to federation. It's too easy to think about Westminster. Most of the time I sort of give up on them. You have to look at what happened in Australia. How did it work out here? We had all of these real democracy nerds in Australia. It takes my breath away, really. They knew about constitutions, the legalities of these things, and they learned a lot of it in the colonial legislature. Busy states after the gold rushes, like Victoria. Did they help to solve this problem?
Well, look, they certainly meant that the framers were aware of the problem. I think that's a really important thing to remember. Like Section 53 isn't an accident because they didn't realise that this power to potentially block or delay supply would be a political smoking political gun. Oh, they were very well aware of that. And they were aware of that because there was already colonies who had elected upper houses. They were well on their way into the democratic experiment, Victoria being one of them, South Australia being another. Like South Australia is really pioneering in the terms of progressive democratic participation, allowing women to vote, for instance. And because South Australia and Victoria in particular had already experimented with democratic upper houses, they had already had clashes between the houses over money. As I said, it's one of those workhorses of the Constitution. Who gets to introduce money bills, who gets to amend them, who gets to reject them. It arose very quickly after the colonial constitutions had set up democratic upper houses. And what we see from the colonial experience is a pretty pragmatic compromise, which is upper houses would not have the power to amend ordinary annual spending bills like the budget, so they aren't able to amend the government's prerogative in determining where money is going to be spent, but they retain the power to reject them outright. And at the heart of this political compromise is the sense that that's a pretty extreme power. It's going to be used in very limited circumstances, but it's kind of like a nod to the democratic accountability of the upper house that you do retain this power, right? And you'll use it responsibly. Is the kind of the unwritten caveat. And then, of course, that colonial experience and that compromise becomes the compromise in Section 53 as well, which is, as you say, sort of not necessarily that unpredictable, because that's where they're looking to. They're looking to the experience of what they know.
It really is interesting when you then look at what happened, the growth of democracy in Australia, people trying to work out what works in Australia, no doubt looking over their shoulders to what happened in the old home, but also his federation approach, looking at exactly how a federal system worked in the US. Did that provide any guidance?
Well, see, what was complicating in the Australian circumstance is that we were looking to the US for two very particular kind of principles, the separation of powers and particular judicial review, because we're going to have a court that has the final say over the Constitution, and also for federalism. But we utterly reject the presidential Republican model, and we want to retain the responsible government, so the Westminster model, whereby the government is drawn from the lower house, whichever party has the confidence of the lower house, or whichever Prime Minister can form a ministry from the lower house before the party system was well established. And then, so that really complicates how useful the US is. And really, they're looking to the UK, they're looking to the colonies. They've taken federalism from the US. But of course, as with many of these transplants and drafting constitutions, that's kind of where they stop. And then they have to work out what on earth are they going to do in the Australian context.
So the message from all of this is that I'm getting is that responsible government is the big thing. You have to understand the concept of responsible government. In Fremantle, where I live, there's what's called the Proclamation Tree, right more or less in the centre of town. And it marks the day that responsible government was given to Western Australia. People spoke about responsible government. They dreamed of responsible government. And it meant that they had their own self-rule, their own democratic system. I think in some ways we've forgotten and lost sight of how important responsible government as a concept is. But if you hold to that, then it's the House of Representatives in Canberra, as you keep saying, for which the government is drawn. They've got the power. They represent the people. And you can come up with all sorts of expressions to say that anybody else who purports to be representative of the people, they don't really understand how this all works, this democracy process. So the House of Representatives, they are the government. They advise the Crown under our system. And so you come back, someone wants to pass a money bill. They want to increase taxation. They want to do something to alleviate housing, and they decide that they're going to change the rules that sort of incentivise people to buy houses and make them more expensive. Whatever the policy might be, it has to come from the government advising the Crown.
Yeah, that's right. And we still have so much of those really UK principles around how responsible government works. We have the fact that the Governor-General has to introduce the money bills, that they have to be introduced into House of Representatives, the lower house. The Senate can't amend them. And if they want to amend them, they kind of have to write a note to the House of Representatives requesting an amendment with respect. And so much of it is just your stock standard responsible government from the UK, but then it hits a wall once it hits federalism, because there needs to be compromises. These smaller states at the conventions in the 1890s, they're not going to agree to a situation where everything happens in the House of Representatives, because that's the national house, and that's going to be dominated by the big states, right? They need to have some compromise, some sort of like little sugar bit given to them to get them over the line.
It is fascinating, isn't it? And the students in particular, the capital S students who are going to be at the convention, they'll be all over the fact that there are these debates leading up to the Commonwealth Constitution being enacted. Surprising, I suppose, as an imperial piece of legislation. It's ours now, not London's. But what were the sort of debates? Who were the sort of people involved? And did they represent these very states' right type views, or were they protectionists or free traders? How did that work?
What is really interesting, as I said earlier, is to remember that the representatives at the convention are a very small group. They are elected. There's a democratic element to the late 1890s conventions, but they're a limited group of pretty wealthy white men. So concerns around women's democratic rights, around labour movement rights, around the rights of migrants, particularly like Chinese migrants, South Sea Islanders and Queensland, they're not really part of the debates that we might be more accustomed to today. No, what is really driving them are concerns around what policies are going to be adopted in relation to trade. Is it going to be free trade? Is it going to be protectionist? They're very concerned in relation to the powers that are going to be given to the new national government versus the powers that are going to be kept by the states. And what's interesting, given how the Constitution has evolved and been interpreted by the court and practiced by the government and parliament, is by far the majority of the framers were states' rightists, and very few were nationalists in terms of having a strong national government. They all agreed that a national government was needed. But so that division between how much power you give to the national government, how much power you give to the states was a big one. And then, of course, there was this big divide between the big states and the smaller states, particularly like South Australia, Tasmania. Western Australia was interesting, as you say, very vocal post-Federation, and has been vocal at particular points, the 1930s being perhaps a high point. But, of course, at Federation, it had only relatively recently been granted full representative and responsible government. It was sort of a latecomer to some of the conventions and not as strong of the voices as those South Australian and Tasmanian delegates.
The term to Section 53, as we now have it, as being legislated and part of our Constitution, did it get resolved early on or later in the constitutional debates?
It was pretty much resolved in the 1891 draft, which is the first convention, which wasn't the democratically elected conventions, where you have a draft that's presented by one of the framers, and it reflects the compromise that had been put in place in the South Australian Parliament between the upper houses. And that doesn't stop the debate, though. It is debated long and hard. Some of the delegates proclaim that this particular issue and how it balances responsible government with federalism is going to kill the constitutional project completely. Like it's an impasse and people won't move from it. And so it's debated in the 1890s, but ultimately it stays as that compromise. But not an uninformed compromise. They knew that it was a compromise. They knew that it could cause problems. But they, as I said, they were balancing responsible government with the federation and the issue, the concerns of the smaller states.
I'll just read back at this point to our listeners who may not have Section 53 in front of them, the essence of it again. And I'll just read the first sentence from the longer paragraphs. Section 53, proposed laws appropriating revenue or monies or imposing taxation shall not originate in the Senate. And then there's more that follows. Next paragraph. The Senate may not amend proposed laws imposing taxation or proposed laws appropriating revenue or monies for the ordinary annual services of the government. The next paragraph. The Senate may not amend any proposed laws so as to increase any proposed charge or burden on the people. In the next paragraph, the Senate may at any stage return to the House of Representatives any proposed law which the Senate may not amend, requesting by message the omission or amendment of any items or provisions therein, and the House of Representatives may, if it thinks fit, make any such omissions or amendments with or without modifications. And then I've read out the very last clause of otherwise being equal. So there it is. That's the 1891 Compromise, as it's called. What might they also have addressed with the benefit of hindsight, or perhaps knowing that it might happen anyway?
Well, look, I think that the experience of the colonies meant that they knew what might happen. I think they were, and they couldn't foresee how politics would evolve in Australia. The rise of party politics, for instance. There were free traders and protectionists, and there was the growing labour movement at the time, but they were largely bereft of what we see now, which is the party politics, where you've got two major parties, or the coalition and the Labor Party, and then you have some smaller parties and independents. This idea that it will be dominated by two major parties was not known to them, but also they discussed at length and they predicted that the Senate would be a very important states house, that it was going to be the house of review for the states. States' concerns would be addressed in the upper house. But of course, that's not how we know the Senate operates today, with a few exceptions. Senators such as Senator Jackie Lambie in Tasmania, very vocal about Tasmanian rights. But by and large, the Senate operates along federal party lines, but has introduced a proportional system of voting, which means that we now look at the Senate as being much more inclusively representative than the lower house, and is stepped into a new sort of constitutional role as being a house of accountability and review, because it's not dominated by the government most of the time, and has this constitutional responsibility, at least in practice, to hold the government to account. Now, that's not what the framers thought the Senate was going to do. So would they have changed Section 53? Possibly. But what we have now is a compromise based on a set of assumptions about how politics was going to work, really, and how it was going to work within the constitutional framing. We now have a modern understanding of how politics is working, although that's evolving, right? The two-party dominance is waning, and there's the rise of the independents. Things are still changing. But the question, I think, is would the Section 53 compromise be the same given how politics is practiced today and how we know the Senate operates today? I'm not saying the answer is one way or the other, but that's really the question we need to ask, rather than thinking, well, did the framers get it right back in the 1890s? Perhaps they got it right for the 1890s, but have we got it right for the 2020s and beyond?
Well, it's said by people who really understand these things, Gabriel, that the words of Section 53, most of which I've read out, most famously created the seeds of the constitutional crisis of 1975. It's ultimately led to the dismissal of the Whitlam government by the Governor-General. So, I mean, in a sense, it's clear, but how did that happen? How did it provide the seeds?
Yeah, sure. So what's interesting, of course, is that Section 53 left the power of the Senate, other than as restricted by the words, as you've read them out, which is in relation to introduction of money bills and amendment of certain money bills, but otherwise the same powers as the House, including to reject. But it doesn't play out at the federal level for decades. It's not that this is an immediate constitutional crisis that arises. It's not until the mid-1970s that we actually get the constitutional crisis arising. And of course, I just want to say at this point, it hasn't arisen since in that very acute way. So it has arisen. It's not to dismiss it, but it is by and large respected as a very powerful and important power of the Senate, not to be used lightly. Now, some people think that the 75 use of the power was used at the wrong time, but we are talking about one incident in our history. I think that's important to remember. But yes, the seeds sit in Section 53 of the Constitution, ready to kind of sprout with the right Senate, with the right political environment. And that happens in 1975. Very, very simple version of the 1975 crisis. We could do a whole series of a podcast about that, and they have been done. But to focus on the role of Section 53, you get to 1975, and there's a lot that has preceded the 1975 crisis in relation to the government led by Gough Whitlam and the opposition led by Malcolm Fraser and the tensions between the two. But by 1975, October 1975, the Senate refuses to pass Whitlam government's annual appropriations, their supply bills. And it's doing so to hold the government to ransom, to force the government to call an election, claims that the government, through various maladministration, has lost public trust. And so it needs to go to an election. The government is refusing. It had done so a year before, but it's refusing this time, saying, no, we have the trust of the lower house. And we are responsible to the lower house, the House of Representatives, and we don't answer to you, basically. You can't withhold this supply. But of course, the Senate's saying, no, look at Section 53. We do have the power to do this. And as a directly elected House, democratically representative, we are entitled to hold the government to account in this way. Ultimately, this leads to the Governor-General exercising his powers, reserve powers in the Constitution to sack the Prime Minister and the ministers. And now he states he was getting very worried that the government was just going to run out of money. He wasn't going to be able to pay public servants. He wasn't going to be able to pay public services and social security payouts, all these very important things that means we are able to operate as a society. And so there had to be an impasse, and he exercises the reserve powers to do so. So the crisis usually focuses on the reserve powers. But as you said rightly, Michael, the seed is in Section 53. The Senate starts it, and Fraser's opposition starts it with that power to block supply.
Slightly with tongue in cheek, some of the students of the convention might say, look, Section 53 is what the Whitlam dismissal was all about, really about reserve powers and the Governor-General at all. The Governor-General just did what the Senate had the power to demand that he do, in effect. I suppose there's something in that.
Yeah, I think there's a relationship, right? There's a relationship between Section 53 and the ability to execute government, right? And the reserve power. I actually think the crisis is about both. But of course, perhaps the most exciting parts of the power is the dismissal bit, the bit where someone actually gets sacked. And so the focus is often on those reserve powers, but Section 53 is where it all starts.
Well, Gabriel, I have a recollection. I'm getting older now. I was actually around when Gough Whitlam was sacked by John Kerr, and really nicely, about 6 or 7 months later, met Gough Whitlam for the first time in a lovely social setting. And he seemed to be quite calm and largely over what had happened at that point. But the whole question of the dismissal and Section 53 and the power of the Senate has sort of bubbled along over time. And I think in the late 80s, there was a constitutional commission set up. I remember going before it and arguing before the commission that the Commonwealth Parliament should have an express power to regulate the environment. But this whole question came up, didn't it? How did they deal with it?
Yeah, so look, the Constitutional Commission did look at both the reserve powers of the Governor-General and recommended codifying those, but also Section 53 and limiting the power of the Senate so that the seeds wouldn't start, if you will. And there's also been an attempt to come back at it in the Republican referendum of 1999, where you had the option of codifying the reserve powers of the Governor-General. So it has been bubbling along. It hasn't arisen in the sort of way that arose in 1975. But constitutional lawyers, constitutional reformists, politicians are all very aware of the latent possibility of Section 53, I think. Yeah.
Well, at the National Schools Constitutional Convention in March this year, the students really are in the same sort of position as those leading politicians and thinkers and scholars were in the 1890s at the convention debates. They can imagine the problem. Here they've got the seeds have sprouted, and they can start to address this. And it might be very important to Australia's future constitutional arrangements, Gabriel.
Yeah, look, I think it's a really important question. Money still swears, it's still a very important part of government. And we see that, in relation to pork barrelling, we see that in relation to debates over taxation, GST. It's still a very important part of our democracy and about our federation. So in many respects, a lot of the tension is still there. And I think as the students of the convention come to it, I think what we can take from the history is to remember that the framers in 1890s did not chance upon the compromise of Section 53. They decided on the compromise of Section 53, knowing that it could cause tensions and potential problems. Might not have been able to predict 1975, but they could see the potential for a standoff, if you will. But nonetheless, they saw that they needed to do it in order to get federation over the line. The question that then arises for a sort of a modern constitutional practitioner, scholar, reformer is that still the compromise that we want? Are the principles still in the same tension? The Senate doesn't operate as the state's house. How does that change our resolution of the tension? Perhaps an easy response to the 1975 crisis is to say, take the power away from the Senate. You can only serve one master, and it is the House of Representatives. On the other hand, we know how dominated, at least at the federal level, the House of Representatives is by the government in modern politics. And what does that really mean that the House of Representatives hold the purse strings for the government? The government controls the House of Representatives, the Representatives holds the purse strings. It's just the government approving its own money. The Senate is really where review happens and accountability happens. Maybe the compromise is the right one now, but for different reasons because of that changing nature of the Senate. These are all the questions that need to be thought through if we're going to come back to Section 53, not just dismissing the framers, not a knee-jerk reaction to 75, but a recalibration of the compromise.
It's amazing, isn't it? Something as dry and apparently not inflammable as Section 53 appears is anything but. The biggest challenge, of course, is that you need to get a government to initiate a referendum bill to change Section 53. What did the Hawke government do when they got I think they were the government who had the Constitutional Commission's report? Was it all too hard?
Yeah. Something that they weren't going to touch. I mean, one of the challenges with a referendum on this type of question is that it's seen as a, government making life a bit easier for itself. And those types of referendums are pretty easy to oppose and are generally not carried because government's making life easier for themselves. It's viewed with scepticism. And I think that if you are going to look at Section 53 again, you need a very well-reasoned argument as to why you wouldn't leave it as it is. Why shouldn't the Senate have that ultimate power, not used very often, once in our constitutional history as a federation? Yes, it was a crisis, but they've been responsible ever since, varying degrees, is removing the power a knee-jerk reaction. And what flow-on effects does that have? We haven't seen it exercised since 1975, but the fact that it's there, the fact that there's a shotgun behind the door for the Senate, what effect does that have on how politics is played out? And if you take it away, what happens to the government and the way that government conducts itself and the powers of the Senate as the House of Accountability and Review? All of these things need to be thought through at the convention with the students are at, because these are the issues that will arise in debate. Should a proposal go to the people in a referendum?
I think all those points you make are absolutely valid. I mean, it's a big intellectual exercise, but I have to say, from my perspective, particularly when you come to democracy, you have to feel something else. It's not just the intellectual side of all of this. It's most emotional. How should our country work? How does the Parliament in Canberra and the federal system work? Yes, what are the states' rights interests here? Because I don't think they've disappeared. I could see a time in the Senate where actually across the aisles, the states' representatives might get together and resist whoever the government of the day is in the lower house. You can't discount these things. So it's great to be able to talk about it. The good thing is, though, Gabriel, when I've left this mortal coil, all these younger students who will have thought about these things will have been prepped by this podcast, and they'll be able to leap into action with your good tutelage on the topic. It's been really interesting discussing it.
Yeah, I've really enjoyed teasing out the issues and learning about your own experience with the post-dismissal wash-up and Gough Whitlam.
Well, it was one of the big issues of our time, and it still bubbles. And I think your comments about if you did go to a referendum on all of this, the issues that would govern the outcome of the referendum would have nothing to do with Section 53 and have everything to do with people thinking whether it was right or wrong that Gough Whitlam went and whether that was good for Australia. And you just won't get the requisite numbers of states and people to satisfy Section 128 and the change.
Which, of course, is a whole further conversation about referendum culture in Australia. And that's another podcast series, I think.
It's another podcast series. Professor Gabrielle Appleby, thank you for joining me today. And I wish all the students a really good time debating this one.
It was a pleasure to discuss this. Thanks, Michael.